Hello, everyone. Welcome to today's program titled COVID-19's Impact on Public and Private Construction Projects Best Practices Regarding Claims, Delays, and Price Adjustments. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for CLE credit. Copies of the webinar recording and PowerPoint presentation will be distributed to attendees in the days following the webinar. At this time, I would like to turn it over to our speaker, Mr. James Newland. Mr. Newland, it is all yours.
Thank you very much, and welcome again to today's program. A couple administrative things to cover at the outset, and then we'll move right into the presentation. Please take a moment to visit our Seyfarth Shaw COVID-19 Resource Center to sign up for daily updates. We are not sending updates out in separate form. We've compiled all of our updates for a day into one single email so that they're presented in a more organized fashion. And then finally, the material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. That said, certainly feel free to reach out to us after the program, and we'd be happy to help you or advise on any of your project-related matters. Okay, I am James Newland, and with me today are my partners David Blake and Leah Rockwarg. We all are in the construction practice group at Seyfarth Shaw. We have very similar practices in that we both, or all of us, represent public and private contractors, and we handle what we call contentious and non-contentious work. And what I mean by that is we do negotiations as well as dispute resolution work. So with the COVID-19 situation, we're presented with a pretty unique circumstance. Many times on projects we'll have delays, we'll have impacts, but they're only related to a specific project. In the case of COVID-19, we've got a pervasive impact, and it's going to impact and is already impacting company-wide portfolios of projects. So it's a unique circumstance. And I think over the course of the next 2 years, there's going to be some new and interesting case law developed. And we've invested a fair amount of time getting up to speed so that we can help you put your best foot forward in presenting or defending against claims.
Okay, one other quick point on, in addition to contractors working on public and private projects, we also represent a number of real estate developers as well as owners on their construction projects. COVID-19 raises numerous issues under construction contracts. Today, we will discuss those issues in the context of a number of FAR clauses used for federal construction projects, as well as AIA 8201 clauses frequently used on private construction projects. Those issues are going to include delay and suspension. That's probably the big issue. People seeing disruptions in supply chains, delays on their projects, owners in some cases proactively considering suspending even when the order of their jurisdiction may not require it due to health reasons. Defaults and termination, doctrines of forbearance, waiver, prevention, and economic hardship excuse a contractor's performance under certain circumstances. Clauses pertaining to illness of key personnel, changes in claims is another big one. We'll talk about timing provisions and things to do to preserve claim rights. Indemnification, certainly those clauses often provide for indemnity for sickness and death of people. And how does that relate to COVID-19 if a construction workforce might introduce the disease to a construction site, especially one that's occupied by an owner, perhaps a tenant fit-out project? There are payment and financing issues and assurances contractors are entitled to we'll go through, partial occupancy and final completion issues, and then we will finish up with some time for questions and
All right, thank you, David. Just to follow up on one point there, there's a fair amount of material to cover here today. And if we don't see your question or we don't get the opportunity to address it before the end of the program, certainly feel free to reach out by email or telephone and pose your question. And of course, if it's related to the program itself, there's no charge for answering basic questions. So when we talk about delay and suspension, I think one thing that needs to be clear to all of the owners and contractors and government agencies is that there are, of course, contract clauses, most of them, whether you're dealing with the Federal Acquisition Regulation Default Clause, which I have on the screen as an example, or you're dealing with the AIA A201, Section 8.3, delays and extensions of time, or you're dealing with Consensus Docs A200 when you talk about delays and extensions of time. All of them have provisions that cover the COVID-19, whether expressly or not. With respect to Consensus Docs and the FAR clause, you can see that epidemics are an enumerated excuse, if you will. They're an excuse for late performance. AIA has a similar provision, but it talks about causes beyond the contractor's control. And so clearly we're in a situation that's beyond the contractor's control. We've got government quarantine restrictions. We've got certain areas of the country, now not most, fortunately, but certain areas of the country where construction can't continue. Boston comes to mind. Here in the District of Columbia and some of our other jurisdictions, that's not the case, where construction's been deemed an essential exercise. But that doesn't mean there haven't been delays. There can be delays for inspections. Certainly there will be, and there have been, delays for materials. Think about marble coming out of, or furniture coming out of Italy. Think about products coming from China, mechanical, electrical, plumbing equipment. All of that will be subject to delays, perhaps substitutions, giving rise to claims. The key point, though, that I think you want to take away is there are two aspects of delay that we want to talk about. One, excusable delay includes compensable delay, where the contractor is entitled to money for a time extension. The money relates to the increased cost of general conditions. And there are non-compensable delays where the contractor isn't entitled to money, but the contractor is entitled to an extension of time that isn't compensable, so time and no money. The non-compensable delays are equally important because if there's a non-compensable time extension, the contractor can avoid liquidated damages. But I think the first and fundamental question and thing to consider is the cases tell us that these causes, these excuses in the clauses, whether they're epidemics, things outside the control of the contractor, et cetera, are not per se excuses, right? So when we talk about per se excuses, we need to recognize that the contractor has to demonstrate the delay. Just because there's been a pandemic doesn't mean the contractor gets to hold up his hand and say, or hold up her hand and say, we all of a sudden get to stop and we get a time extension. The cases indicate that you need to demonstrate that, and that should be fairly obvious. That doesn't mean that it's an onerous burden, but certainly we'll look at the critical path of the project schedule and see how the pandemic actually impacted the work itself. Okay, so when we talk about these types of things, and in the mode we're in now, whether you're an owner or a contractor, documentation of what's going on is very, very critical. Now, when I talk about these programs in other contexts, I make the point that there is an art and a science to all of this. The science is know what the contract requires, follow the notice requirements. The art of the matter is knowing how to deal with your contractor, knowing how to deal with your owner, so that you can cooperate to the extent you're able and mitigate and overcome some of these delays. And to the extent that we have a pandemic that is pervasive across portfolios, I think we're in a mode where owners and contractors certainly need to roll up their sleeves and try to resolve these delays and issues. I also want to talk about sole or concurrent delay. With respect to epidemics, there are not a lot of private contract cases. So if we go to the case law and we try to get an interpretation of a contract clause, there aren't a lot of clauses dealing with epidemics. There are several on the government contract side, and the principles are generally the same. There isn't much of a distinction between the government and the private construction world when we talk about delays. And so when we talk about delay, that same per se rule is going to apply. That is, it's not a per se excuse. The contractor will have to demonstrate delay. And when we talk about delay, we're also going to parse out whether there's a sole delay or concurrent delay. In much of the cases that we'll read, again, because there is a dearth of non-government contracts, epidemic cases, some of the cases will say that the epidemic or COVID-19 needs to be the sole cause of delay, right? Because they're dealing with supply contracts or commercial item contracts. They're not dealing with construction projects. And in the context of a construction project, the rules are a little bit different in that we recognize concurrent delay. Concurrent delay, quite simply for our purpose, is defined as simultaneous delays, one caused by the contractor and one caused by the government. Now, the rule is in most jurisdictions, not everyone, but most all of the jurisdictions, is that a concurrent delay results in a non-compensable time extension. And that's important because although the contractor doesn't receive his or her damages for a delay, their extended general conditions costs, they will get a time extension, and that time extension can be used to overcome a termination for default or the application of the owner's liquidated damages. Again, whether you're dealing with the FAR clauses, the AIA contracts, or the consensus documents, the legal rule on concurrent delay is probably going to prevail in the jurisdiction you're in, so we'll need to sort through some of those things. Another interesting topic that comes up is forbearance of the right or forbearance of a waiver. COVID-19 right now has created a period of uncertain action, right? We've got a period where people aren't necessarily sure how they're going to proceed. We're still trying to understand the impact of COVID-19 on the work, supply chains, etc. And there's an interesting case from the government contract side that I think will translate to the private side, where the government had the right to terminate. There was already a late performance, but the government worked with the contractor, and as we say in the second bullet point, vigorously and actively proceeding with efforts to perform. And when the government's conduct and actions of its agents encouraged and induced the contractor to continue with performance, and in particular incur further expense in connection with the performance, the board determined that the government had lost its right to terminate the contractor. And in fact, in that case, the board converted a termination for default into a termination for convenience. Now, whether that translates to the private sector remains to be seen, but I think it's going to be approached in a similar way, in that courts will look at the course of dealing, and that's what really the ACE, the Armed Services Board of Contract Appeals, was looking at in ACE Electronics. They're looking at that course of dealing. If, on the other hand, the contractor stops performing, doesn't work with the owner, doesn't indicate that it's trying to continue performance notwithstanding the delay, and the owner doesn't do anything to induce the contractor to continue to perform, I think the terminations, for most part, will be upheld. Here's also a topic that is very timely, and that's illness of key personnel. Illness of key personnel is problematic in the sense that a contractor may be using the illness of key personnel to overcome a default termination. And on the owner side, we should look at it as well, because remember, the owner, and more particularly its architects and engineers, have contract administrative duties such as responding to RFIs, approving and reviewing submittals, that type of thing. And when all of that is delayed because key personnel who were actively involved in the project, whether it's a project superintendent, which is probably the most important one of the key personnel, just in my experience, when they're away from the site, right, there's going to be someone who can step in and fulfill that role. The question in my mind is, what's the contractor's compensation there? When we have to substitute key personnel, right, there's going to be a ramp-up period, there's going to be a learning curve period, and the contractors will want to know how they put their best foot forward in seeking compensation for that change in personnel. But remember, just like delay, it's not a per se rule. We really need to link the activities of that key person to delays on the project. And in most cases, this isn't going to be a situation, I anticipate this isn't going to be a situation where the lack of a key person results in a default. It's really going to be the cost involved and the time involved in the learning curve of getting a substitute person involved in the project. Then let's talk about two more quick topics. One is the prevention doctrine, and I think the only thing I really want to reference here is that we could have situations where a contractor or a subcontractor, for lack of a better phrase, shot themselves in the foot just a bit, because we may have a situation where a contractor's pacing its performance, and what I mean by that is they've got some float time, they haven't been diligent, and more particularly, perhaps a subcontractor hasn't been diligent in preparing RFIs or submittals, and they didn't get in according to the time they were supposed to get in according to the submittal schedule. And now we've got a situation where delay may be reviewed because the architect and engineer may be working remotely, or they've got key personnel that are out. And so when we look at delays, particularly from the owner side, if you're dealing with a contractor claim, you're going to want to parse through and see if there are things like we call sequential or concurrent delays. A sequential delay just meaning the contractor or the subcontractor was already delaying parts of the project, for instance, the RFI that should have been submitted earlier to get information, or the submittal was delayed, and now we've got a bigger delay. And so delay experts sometimes will parse or apportion responsibility for those types of delays, so just be aware that that's there. And then finally, I'll just mention in passing economic hardship. In the cases that you see on the government side, the economic hardship really relates to a contractor getting an excuse for a default termination. But here I think we're going to see several claims related to substitutions of materials, particularly materials that are unavailable. And so I think contractors will want to go to the owner, demonstrate that they can't get certain materials, whether they're coming out of a country that's under quarantine or lockdown, or now we're trying to substitute with a domestic source of supply, and they're overwhelmed. So I think the contractor would probably, in that case, present a delay claim and then negotiate a substitution with the increased cost of that substitution.
Thanks, James. So I'm going to talk to you a little bit about the key clauses affecting performance and clauses in the AIA contracts and the FAR provisions that may come into play in light of COVID-19. Just a few things before I launch into the clauses. Some things to keep in mind, folks. We're going to review some of the more critical provisions appropriate to the current situation under the AIA contracts and also government contracts. Keep in mind, though, that in any negotiation and any contract, as Jim pointed out earlier, the devil is in the details. You need to document carefully. Documentation is key, but keep in mind as well that education is what you get when you read the fine print, and experience is what you get when you don't. Every contract may be different. You might have hundreds of contracts or more. You need to review those provisions carefully to determine whether there's a bespoke agreement and there's some variation in a clause that might otherwise be standard form. Keep in mind also that contracts entered into since knowledge of the pandemic may not afford you the same relief from performance as those that were negotiated prior to the COVID-19 epidemic. For instance, COVID-19 is now known, and if neither party should be responsible, you must include language in a new contract going forward, or contracts negotiated and entered into since the announcement by the World Health Organization of a pandemic, if you seek to rely upon it. There's still a lot that's not known about the coronavirus and the disease that it causes, COVID-19. It's uncertain as to how long it will last and the potentially resounding impacts. So we encourage you to review your contracts carefully with all the key players, including insurance and legal counsel. In addition to the topics that we're going to talk about here, the provisions in the FAR contracts as well as those under the AIA, keep in mind that there may be other contractual, common law, or statutory remedies available, whether it relates to what is called act of God, force majeure, vis major. Those things are all important considerations. There are statutory force majeure provisions that might be available to you under the Uniform Commercial Code for sale of goods, substituted performance, excuse by failure of presupposed conditions, and the like. Additionally, under lease contracts, many states have enacted Uniform Commercial Code provisions that relate to leases. There may be a substitution of performance available or an excuse for performance. Let's talk now about the specific FAR provisions enumerated in the slide before you. So, which FAR provision or which FAR clause should I use in the event of a delay? Should I use the changes provision? How about the suspension provision? For scope of work changes, those should be addressed by the changes clause. If COVID-19 and the government's actions, delays, and other prime contractors or a quarantine restriction results in an express or a constructive change in the work, then as a contractor, you should consider basing your claim on the changes clause. In situations where the scope changes result in delay, cost of delays arising from those changes are recoverable under the changes clause and not the suspension of work clause. So in that instance, you would want to proceed under the changes clause of 52-243-4. Delay claims arising under suspension of work don't allow contractors to recover profit, while the changes clause do not preclude recovery of your profits. So again, you can see the dramatic difference between electing going forward under the changes clause versus the suspension of work clause. In terms of timing, and Jim's going to get into some more detail on these FAR clauses, but in terms of timing, you should be alert and aware as to what the timing is of presenting any such claim. If an order comes as an express written order designated or indicated to be a change order from the government, then you should notify the government in writing of any cost or schedule impact within 30 days of the receipt of that order. And with the exception of a signature certifying a CDA claim under the Contract Disputes Act, then email notice will suffice. You have to certify your claim. You have to proceed in accordance with the requirements of the regulation. Stop work orders under 52-242-15. Keep in mind that this provision provides that the contracting officer may at any time, by a written order to the contractor, require the contractor to stop all or any part of its work required by the contract for a period of up to 90 days after that order is delivered to the contractor. And it can extend that period to the extent that the parties agree. If such case arises, when you receive that order from the government, you must comply with its terms and take all reasonable steps to mitigate the costs allocable to the work that's covered by that order during the period of any given work stoppage. So you need to read the order carefully, and you need to understand the timing of any response and notice to the government again. So before that 90-day period expires, if there's no extension agreed to between the government and the contractor, then the contracting officer must lift that stop work order and terminate the contract for convenience or default. Let's talk a little bit more about suspension of work under the FAR provision 52-242-14. The contracting officer can order the contractor in writing to suspend, delay, or interrupt all or any portion of the work of the contract for a period of time that the contracting officer determines is appropriate for the convenience of the government. Once that work is suspended, you as the contractor must give prompt notice under subpart C, because the clause limits recovery of costs incurred more than 20 days prior to notification to the contracting officer of any act or failure to act causing such suspension or delay. Talk a little bit about termination for convenience of the government under 52-249-2. If the contracting officer determines that termination of the contract is for the government's interest, is in the government's interest, then the government can terminate that contract for its convenience. it must therefore deliver written notice of termination, describing the extent of the termination and the effective date of any such termination. Once after that period has expired, the contractor is to submit its final termination settlement proposal within a year unless that time frame is agreed to be extended by the contracting officer. And finally, a couple of thoughts on the use or possession prior to completion under 52-236-11. Consider the situation where the owner actually occupies a portion of any given facility and brings into the situation or the facility, someone who's contracted COVID-19. In any kind of a situation like that, that may result in additional cleaning and disinfection, resulting in additional costs and expenses, not to mention exposure to others, has a myriad of implications, and therefore there may be costs and expenses associated with any such claim arising out of that situation. Turning to the AIA provisions that David's going to get into in a lot greater detail than I've got about 2 minutes per slide. Evidence of the owner's financial arrangements, you're entitled to that as a contractor unless your contract provision has been modified. So keep in mind, look precisely at what the language of your contract says with regard to your ability to request evidence of the owner's financial arrangements. Typically, at the outset of a given project, you'll find that the owner will provide you with evidence of their financial situation and ability to pay you. In light of COVID-19, the owner's ability to pay may have changed dramatically. It behooves you to consider whether you would request from the owner evidence of financial arrangements so that you can proceed with the work before doing so and run the risk of not being paid for work that you end up doing. Similarly, the indemnification language of your contract is important to review. What are the obligations associated with the owner's and the contractor's indemnity obligations? If there's cross-contamination, if there's other issues that arise, there may be a trigger for the indemnity language in your contract, and David's going to get into that in more detail. Concerning changes of the work, the same types of things apply with regard to Article 7 of the standard AIA A201. There may be changes that are driven by changes in circumstances, increased scope and work. We talked a little bit about increases in work due to cleaning and disinfection requirements and other related issues, additional safety precautions, the use of PPE and other equipment that was not otherwise contemplated by the parties at the outset of the project, all giving rise to either government mandates or other requirements on the project. And there may be an ability to recover those costs under your contract, but again, timely notice is key. Delays and extensions of time, again, you need to, whether it's in the Federal Acquisition Regulations context or the AIA private contract context, you need to make sure that you comply with notice and claim requirements of the delays and extensions of time, and there are variations under the delays and extension of time provision under Section 8.3 that David's going to get into to explain to you the importance of why notice is important and what the remedies are that are available under the standard provisions for both the owner and the contractor. Under Section 9.7 of the A201 2017 version, there are also issues associated with a failure to pay and remedies associated therewith. Partial use and occupancy, I mentioned that briefly in the context of the Federal Acquisition Regulations. And I know I'm getting a little bit far behind on time, so I'm going to rush through these, and I apologize for doing so. But be certain to follow the notice and claim provisions of your contract. There are provisions and the same issues that I talked about a few minutes ago concerning the Federal Acquisition Regulations apply to these AIA provisions that David's going to get into in a lot greater detail. And I'm going to turn it over to Jim to talk a little bit more in detail about the FAR clauses. Jim?
Yeah, thank you, Leah. So I think Leah set the table pretty well for talking about most all of these clauses. So I'm going to hit the higher points here and then talk about some strategy issues. On the FAR changes clause, the Federal Acquisition Regulation changes clause, which is the fixed price construction clause that most all government contractors are used to seeing. It's similar to the AIA clause and similar to the consensus document clause in that the owner has very wide discretion, almost unfettered discretion, to implement changes in the work. Changes in the work can be implemented by the owner anytime it wants to, leading up to completion of the project. The only limit on that are cardinal changes, which are very, very rare. So we have two aspects of changes, regardless of what type of clause, public or private, we're working with. Under the FAR regime, though, the federal acquisition squarely deals with what we call constructive changes versus express changes. Express changes are covered by Part A of the FAR clause, FAR 52-243-4, and they're very straightforward because the contracting officer or the government's representative writes to the contractor and says, here is a change in scope. Here is something designated to be a change order. And again, wide discretion, including acceleration, including descoping work, including changing the specifications or the manner or method of performance, and importantly, changes in government furnished property, because as we'll see as we go through this, if there's a separate prime contractor to the government or the owner under the AIA or consensus documents, the private owner is going to be responsible and the government's going to be responsible for that separate or private contractor's, separate prime contractor's delay. Very straightforward for express changes. We know there's a change order. Part B, though, deals with any other written or oral order that's not addressed or styled or titled as a change order, but includes some kind of clarification or direction or instruction or interpretation where the government doesn't believe that it's changing the scope of work, but it merely is interpreting the contract. It's giving instruction or an interpretation to the contractor. When that happens, the contractor just writes back and says, we believe that this is a change in scope, and so we're treating it as a change order. And from that point on, from that point where they notify the contracting officer that it is a change order, they have the same notice time frame to perfect their request for equitable adjustment, which is 30 days. On constructive changes, though, again, changes that aren't styled as a change order, there's a 20-day look-back period on costs. So the contractor is going to want to get that notice out before the end of the 30-day period and get it out early, I should say, so that the contractor doesn't run afoul of that 20-day look-back period. Now, the only other point I'll make before I turn it over to the AIA clause and let David explain is to follow up on something that Leah mentioned, and that is when you've got a delay that arises from a change, you're certainly, as a contractor, you're certainly going to want to base your entitlement to a compensable time extension on the changes clause and not the suspension of work clause. It's well settled in government contracts law that if a change gives rise to a delay, the compensation for the delay arises under the changes clause. That's important, again, because the suspension of work clause that would otherwise otherwise entitle the contractor to a time extension for delay doesn't allow profit.
Those working on the private side, we're now going to go through a series of A201 clauses and specifically talk about how they may come into play as a result of COVID-19. The first one pertains to changes. We're all generally familiar with the concept of when the contractor agrees on the terms of a change, the owner can use a change order signed by both parties. When the contractor does not agree on certain terms of a change, the owner can direct a change through a construction change directive. These options are set forth in Article 7 of the A201. Under both models, the parties should be aware of issues due to COVID-19. First, in a change order signed by the owner and the contractor, owners should look out for reservations contractors might add, stating the lump sum amount is subject to adjustment if prices escalate due to COVID-19 supply disruptions. Now, what I have seen on a number of projects working on behalf of owners is that typically the contractor will prepare the change order and send it to the owner for signature. So I mentioned this just to keep an eye out for any sorts of reservations that might come up towards the bottom of those change order documents. However, in the same vein, contractors may want to add those types of reservations in order to protect the unknowns of what pricing might be down the road. Owners also may want to carefully review backup for lump sum pricing, see if contingencies were included due to COVID-19. I'm not saying that those would necessarily be unreasonable, but perhaps take a look at them to get comfortable with whether they seem reasonable under the circumstances. For construction change directives, absent agreement on price, the contractor is generally going to be entitled to recover the additional costs associated with the change. Basic concept involving directives. What's at play here is those costs could be significant due to COVID-19 impacts. And we mention this because owners might want to think twice before utilizing construction change directives in this environment. If necessary, so be it, but if not, again, you might want to take this into account. Section 15 dictates if a contractor believes it has been impacted by COVID-19, including a change related to it, it needs to initiate a claim within 21 days after the occurrence of the event, giving. Next is a slide concerning financing provisions in 1. Contractors are entitled to obtain from owners proof of financing before commencing construction. Additionally, if the contractor has reasonable concerns during the course of construction, require the owner to provide proof of financing for its remaining obligations. For this and other reasons, owners should confirm financing before executing the contract. Construction lending could be pulled due to COVID-19, and the last thing you want is to sign your contract and then find out that the financing is secured. In this vein, owners should also consider measuring commencement from a notice to proceed instead of the date of the contract. You typically have the option of measuring commencement from the date of contract and then having a date certain for scheduled substantial completion, or measuring commencement from the issuance of a notice to proceed, with the scheduled substantial completion being a certain number of days following the notice to proceed. By utilizing the notice to proceed option, financing is delayed, the owner can postpone issuing the notice to proceed and protect the pricing agreed upon in the contract. On the other side of the coin, contractors may want to include an outside date for the notice to proceed so that their pricing does not put them in a disadvantageous position where there is significant price escalation and now they're locked in. Lending concerns due to COVID-19 might provide grounds for the contractor to request evidence of financing during the course of performance. As the clause shows us, failure to provide could support work stoppages, time extensions, and additional compensation. Owners should expect these types of requests in the environment we're now working within, prepared to respond. Next is the indemnification clause. The indemnity provision in the A201 is something most parties are familiar with, and it's often discussed and negotiated in preparing the contract. Within the text, there is language that could support indemnification for claims based on COVID-19. We see the contractor is required to indemnify the owner for sickness, disease, and death caused by the negligence of the contractor or its subcontractors. So the key here, Jim mentioned before, these things are not per se, but here the owner has to establish negligence on the part of the contractor or. In the context of COVID-19, if an employee of the contractor or subcontractor has COVID-19, comes to the site and infects the owner's employees or guests or the architect working in its construction administration function, this indemnity clause may be triggered. Now, the owner, again, needs to establish the contractor acted negligently, allowing a worker on site that is known or perhaps even reasonably suspected to be infected constitute negligence on the part of the contractor or a sub. Negligence might also be established if the workers are not abiding by social distancing guidelines, not using personal protective equipment, or otherwise not following state or local health orders, and that might fall on the contractor's shoulders in terms of being required to enforce those types of things. This type of issue may be more prevalent in TI or rehab work where there is a likelihood of increased interaction between owner and the construction workforce rather than a ground-up construction that isn't occupied during the course of the CIA delay clause. This is ones to COVID-19. Section 831 entitles a contractor to a time extension for delays beyond its control. Leah did a nice job featuring issue. Some examples are provided in the language of the clause. The list is not prescriptive. Based on this language, any cause beyond the contractor's control is grounds for a time extension. Any COVID-19 related delays could fall within Section 831, entitling the contractor to a time extension. These include owner-directed changes to overcome COVID-19 issues, unusual delay in deliveries due to COVID-19, such as travel, shipment, quarantine, and country shutdowns. For example, marble or other fine stone might be held up in a port in Italy. And delay due to inefficiencies arising out of construction workers complying with government health orders and guidance, such as wipe down of areas and wearing personal protective equipment. One example with respect to social distancing, it could result in only allowing one person in a man lift at a time, necessitating more trips up and down a building, eroding efficiency, prolonging performance periods. Keep in mind that a time extension pursuant to Section 831 neither establishes nor prohibits entitlement to additional compensation. 3, monetary delay claims must find their basis under another contract clause, such as a change. Also, be mindful of case law. Some jurisdictions limit a party to the specific excuses listed in the contract and do not enforce catch-all language, such as other causes beyond the contract. In those jurisdictions, you are in fact limited to the delays that are set forth in the body of the contract.
Great, thanks, David. I want to talk a little bit about termination and suspension under the AIA, but before I do that, I want to give the CLE code. CLE code is S as in Sam, 8611. That's SS 8611. So looking at section 14.3.1 of the AIA A201, an owner, as you can see, may direct the contractor to suspend performance for any reason, including COVID-19, and doing so entitles the contractor to additional time and money attributable to any such suspension. If an owner is considering shutting down its construction site for the good of those involved, health and safety reasons, local orders, statewide orders involved due to COVID-19, it would benefit both parties to enter into a side letter stating that the parties agree to a suspension, that the suspension is in everyone's best interest, and that an appropriate time extension will be granted, but no additional compensation will be owed. That is one way to for the parties to work together in a more collaborative manner. We're all in this together, and under the circumstances, it may result in avoiding a dispute down the road. Turning to the section 14.1.2, the termination provision entitling the contractor to terminate under certain circumstances, if the owner suspends the work for an extended period of time due to general health concerns arising out of COVID-19, for example, it could trigger the contractor's right to terminate under section 14.1.2. On the last slide that I just reviewed, we mentioned the use of a side letter for an owner-directed COVID-19-based suspension. The parties may want to consider in incorporating language into that letter stating that there's no right to terminate under this clause because the suspension is either for the health and benefit of everyone on the project or for reasons due to other orders, local or otherwise. You'll see in this slide in section 14.1.2, we've underlined some of the language. We underline that because a shutdown might be driven by the contractor or a subcontractor not properly adhering to state or municipal orders, resulting in them bringing inadvertently or otherwise the virus to the site and infecting either other workers or workers unrelated to the project itself, and that may result in a localized suspension. Under those circumstances, the contractor should not be able to invoke its rights under this termination provision as otherwise might apply. Turning over to the section 14.2.1 under the AIA A201, owner's right to terminate. Under section 14.2.1, the owner may terminate the contract for any of the enumerated reasons. Now, we've highlighted repeated disregard of applicable laws, statutes, ordinances, codes, rules, and regulations, or lawful orders of a public authority. If the contractor, for example, repeatedly ignores state, municipal, or other applicable orders regarding social distancing, work restrictions, the use of personal protective equipment, and the like, there may be cause for termination under section 14.2.1. David?
Thanks, Leah. Section 991 allows an owner to occupy a portion of a project that is complete or partially complete before the entire project is substantially complete if the contractor consents, and that consent is not to be unreasonably withheld. If an owner partially occupies part of the project, it might infect contractor personnel with COVID-19 or contaminate the work area, requiring wipe downs, cleanup, could interfere with productivity. Accordingly, a contractor may want to take these issues into consideration, has to consent to partial occupancy circumstances with these, and secure in writing reasonable protections against these risks. It might include indemnification for sickness, disease, and death due to COVID-19 spread by the owner, similar to the indemnity that the owner benefits from under Section 318. If the owner's partial occupancy will result in the construction workforce following enhanced health measures so as not to sicken the owner, the contractor may want to secure an agreement from the owner for compensation for additional costs associated with those additional measures, including related inefficiencies. In the same vein, a contractor may want to obtain an acknowledgement from the owner that those measures could cause delays, entitling the contractor to a time. Section 9.7 allows the contractor to stop work if the owner does not pay it within 7 days of the date for payment established in the contract. Under the A101 and most other AIA agreements, in my experience, owners usually agree to make progress payments within approximately 30 days after receiving. Funding sources dry up due to economic shocks COVID-19 is causing. Owners may become unable to pay for work performed, entitling contractors under this language to stop work. Further, the contractor is also entitled to a time extension and additional compensation, additional costs it incurs to shut down and restart its operations. Owners do not have a ready defense to this scenario under the A201. Section 8.3 that we looked at entitles a contractor to a time extension for delays beyond its control, but that's one way in favor of the contractor, and by that I mean it does not excuse an owner's non-performance, such as non-payment, due to conditions beyond the owner's control. There is no bilateral force majeure type language in the A201. Further, other types of contracts that do include bilateral force majeure clauses often state that they do not excuse a party's non-payment. However, governing case law may provide common law defenses to an owner, such as impossibility, frustration of purpose, and acts of God, and therefore should be reviewed. Seyfarth is currently conducting a 50-state analysis of those common law issues, whether they provide defenses, including for non-payment. clause is IA final completion clause. And for this one, Section 9.10.3 provides that if after substantial completion, final completion is materially delayed through no fault of the contractor, the owner will pay the contractor for balance due for work that's complete. Relevant here because a work stoppage due to COVID-19 that occurs after substantial completion will entitle the contractor to payment of the remaining amount for work that is fully complete based on this. Owners may want to consider this in connection with projects that are nearing completion. If safe to do so, it may be advantageous to close those projects out in order to avoid triggering this provision. In the grand scheme of issues we're seeing due to COVID-19, this is not a major one, but we did want to bring it. Slide. One moment while we restore audio.
Okay. Hopefully you can hear me now. We're on the suspension of work clause under 52-242-14. Suspension of work is one of the key clauses that's going to come up, if it has not already, on your government contract projects. And there are 2 points here I'll make, and they mirror to some extent what we talked about with respect to the changes clause. What I mean by that is, under Part A, there's express suspension, and under Part B of this clause, there's constructive suspension. The express suspension is easy. That's where the contracting officer writes to the contractor and says the government is suspending, delaying, or interrupting the work, and they're going to specify whether they're going to suspend, delay, or interrupt all of the project, all of the remaining work, or just a part of it. So if we've got one part of the project that's susceptible to delay in particular materials or government furnished property, or another prime contractor that's hired by the government might elect to suspend only that part and let the contractor continue with the rest of the work. Constructive suspension is different in that there isn't that letter or that order that says stop or suspend the work for this part of the project or the whole project. That's where the government, and specifically the contracting officer or the contracting officer's technical representatives, are late in fulfilling some of their duties, or they don't fulfill them at all, and that constructively suspends or delays or interrupts the work. Now remember, if that type of situation arises in connection with a change, right, or for instance, a request for information that translates into a change later, you're going to want to pursue that under the changes clause, not the suspension of work clause. But the suspension of work clause covers those types of delays and suspensions where the work is stopped in whole or in part, right? And to the extent that suspension or delay is unreasonable, the contractor is entitled to its increased cost of performance. Remember, similar to the constructive changes aspect of the changes clause, there's a 20-day look-back period coming from the time the contractor gives notice of that constructive delay or suspension of work, where the contractor is going to be limited to costs incurred within that 20-day period. On the termination for convenience, I think ultimately we'll see many projects that are now in suspension mode or just under a delay may ultimately be terminated for convenience. And that convenience, like suspensions, can be partial or in total. There are different time frames, and there's a whole host of activities that take place with respect to terminations for convenience. If the termination for convenience is partial, that is, the whole contract has not been terminated, the rest of the work continues, and the contractor has 90 days to submit its request for equitable adjustment relating to the part that was terminated and any impact it may have on the part that continues. If there's a termination in full, a termination for the convenience of the government of the entire project, then there's a fair amount of work to do. That 90-day period doesn't apply to that type of in toto termination. And instead, over the course of the next several months or within the next year, the contractor takes steps to terminate the subcontractors, terminate the vendors, negotiate settlement proposals with those terminated subs and vendors so that they get paid for the work they provided. The contractor hands over the completed work to the government. It may be asked to assign certain subcontracts and vendors. It does the make safe work, right? So that if we've got a building that's partially completed and it may not be 100% dried in, the government may direct the contractor to complete enough of the work so that the building is dry and protected. It will certainly, for electrical, include cap and make safe, that type of thing. But there are different time frames involved here because that, rather than having a 90-day period, the contractor does all that work, which understandably takes a fair amount of time. And then within the 1-year period thereafter submits its own termination settlement proposal. Interestingly enough, on some of our other projects, we're seeing the opposite result. I know on some airport projects around the country, I was on a call the other day, and the airport authority is actually giving the contractor additional work to perform because they've got funds available, and due to the limitations on travel and the sharp decrease in travel, it's not as busy at the airport, and they have access to other parts of the airport space that they might not have if the airport was operating in full. And then the most drastic of all remedies, of course, is the termination for default. Again, we talked earlier in our very first slide about the enumerated excuses. The ones in play under the FAR termination for default clause are involved in Part B, where it says the contractor's right to proceed shall not be terminated, nor the contractor charged with damages under this clause if the delay in completing the work arises from unforeseeable causes beyond the control and without the fault or negligence of the contractor, including the acts of government in its sovereign or contractual capacity, that being restrictions on work, stay-at-home orders, quarantine restrictions, acts of another contractor in the performance of the contract with the government. That applies equally on the private side, whether you're under the AIA documents or the consensus documents, where there's a separate prime contractor that delays the work. The owner or the government will probably have to answer in damages there. Certainly epidemics and quarantine restrictions. The key aspect of the termination for default clause is if you've got this delay, a delay arising, you're going to want to give notice early and potentially often, as they say, because you've got a 10-day trigger under B2. That said, on the government contract side, strict notice requirements are not always enforced. In fact, the rule is they won't be enforced unless the government demonstrates some prejudice due to the lack of a timely notice. Now, let's just conclude with this. What is the form of notice? It's important. Under the FAR, email suffices. So if you're working on a government project and you're working under the Federal Acquisition Regulation, the FAR defines email as an acceptable form of notice. The only thing you've got to worry about is if you're submitting a certified claim, you don't do that by email without a verified symbol of an individual indicating consent to their signature to authenticate the writing. That's a fancy way of saying you can't just send an email with your standard email signature at the bottom, serving as the Contract Disputes Act signature for the claim. Any other context outside of a CDA claim, email is fine. Email notice of a delay is certainly fine. On the AIA side, it's a little bit more problematic. On the AIA side, you need to specify that email suffices for notices. The standard under the default unmodified A201 and A101 require email to be specified. It can be covered by the electronic protocol document E203 if you use that document. If not, certainly consider allowing email to suffice and including it expressly in the contract. You need to do it not only for notices, but you need to address it in the context of claims, because under the default rules under that form contract, claims are served in paper form.
So thanks, Jim. Good afternoon again, everyone. We apologize that we're out of time and won't be able to answer your questions during the course of this program. However, we encourage you to provide us with your questions, and we will do our level best to answer them for you. We do have a myriad of questions that have already been asked. With unprecedented situations and the fluidity of the situation, with anxiety at an all-time high, we appreciate you attending today's webinar and encourage you to reach out to us so that we can assist you in any way possible. There's no uniformity of the stay-at-home orders, the shelter-in-place, what means essential services, who are essential workers. We've got CISA guidelines, their own definitions of what essential workers and services are, and they're not identical to the CISA guidance. You must familiarize yourself with state and local orders, public health guidelines, and the like. Novel issues ranging from if we do have essential workers and essential services, how do we interpret the stay-at-home order and the moratorium on certain services? We can help clients provide guidance to clients concerning letters that they may want to have their employees, for example, carry who are deemed essential workers so they can present them to the law enforcement authorities if they're stopped. There are so many issues that we could talk about today. We only have an hour. Apologize for the brief audio interruption, but encourage you to reach out to David, Jim, or myself with any questions. And if we can't answer your questions directly, we will help you find the right person at Seyfarth who can assist you with all of your needs. Jim and David?
Thank you, Leah. Thanks, everyone.
All right, well, that concludes today's webinar. Everyone, I want to thank you for attending. Have a wonderful day.